Viewers, we speak on a very, very consequential day today. Very consequential for jurisprudence. 2020 Delhi riots accused Sharjeel Imam and Umar Khalid have been denied bail. It is fair to say that the Supreme Court's decision rejecting the fervent bail pleas filed by Imam and Khalid came as a surprise. Of late in 2024 and 2025, the top court had clarified that even under strict statutes like the UAPA or the PMLA, constitutional courts retain the discretion to grant bail if trial delays are undue or if allegations lack a prima facie basis. In Imam and Khalid's case, pre-trial detention was a serious constitutional concern. The duo had already spent 5 years in prison, as you know. Time lost in jail, liberty lost in jail can never be gained back. So the expectation was that the Supreme Court would relent and release the duo. But clearly the apex court had other ideas, and in denying bail, the Supreme Court has sent out a clear and consequential warning. The court has ruled that prolonged incarceration cannot become a trump card when national security is at stake. Liberty, it says, cannot be invoked in the abstract if the prosecution places prima facie material pointing to a deliberate action against the security of the nation. More significantly, the Supreme Court has widened the legal understanding of terror. There is a parallel argument going on about this too, whether it has or whether it hasn't. But it is held that a threat to society may arise even in the absence of physical violence, and that conspiracy, disruption of essential services, and the deliberate destabilization of civic life can themselves appoint or amount to a terrorist act. So let me just read you through some of the more quotable quotes from the Supreme Court judgment. These are excerpts. Supreme Court says, prosecution disclosed prima facie roles of Umar Khalid and Sharjeel Imam. The court satisfied to the extent of planning and organization of these individuals to commit the act that they're accused of. Sharjeel Imam and Umar Khalid's role are central to the conspiracy. This is what the court has noted. Umar Khalid and Sharjeel Imam stand on a different footing than the others. So 5 others have been given bail. And the Supreme Court goes on to say that delay alone cannot operate as a trump card for bail. Offences regarding security of the nation require a different bail regime. And nation security, preservation of public order, important facets, which they have taken into consideration. The bench has, that is. And terrorist act, not only violence but also disruption of essential services, and the assessment of persons' liberty is different in cases of threatening foundation of the state. And last but not least, incarceration only due to mere passage of time cannot be considered a punishment. So this is what the bench has said in its findings, and therefore has made a case to reject the bail applications of these individuals. Now, this is not just a bail denial, it's a judicial warning. That's how some are interpreting it, a warning that protest has constitutional limits, that intent and coordination matter, and that disruption cannot always cloak itself as dissent. So you have the court saying, and this is a bigger sort of response to the petitioners, that it's unfair. Prolonged incarceration without trial is unfair, it's prejudicial, and therefore we must be given bail. But the Supreme Court is interpreted, as I just pointed out, viewers, differently. And the UAPA has been upheld in letter and in spirit, which means that these individuals will be in jail, though for a period of 1 year. That is because the court has also come out and given the prosecution time to begin the trial and at least submit the testimonials of witnesses that are instrumental to this case. And here's a little ready reckoner that helps recall why Imam is in jail while Umar Khalid is in jail. First of all, with regards to Sharjeel Imam, He's accused of calling out to a particular community, to the Muslims, to cut off the chicken's neck, or India at the chicken's neck, which means that the northeastern states of India, if this massive Chakka Jam, as it is being called, had been successful, would have been effectively cut off from the mainland. He is accused of issuing a call to paralyze government via mass road blockades, action at protest sites to humiliate the government, and threatening to teach the court also a lesson. These are all accusations. Predictably, politics has followed the law and followed the Supreme Court ruling. The opposition alleges vendetta politics, accusing the BJP of tightening the screws on Muslims and questioning the centre's role. The BJP has hit back, saying the ruling reaffirms judicial independence, that foreign pressure will not sway Indian courts, and that this judgment is a message to urban Naxals and Islamist sympathizers. Now, viewers, the views are ranged on both sides, as I have just suggested to you. But we're not going to dive straight into the politics. We're going to look at some of the implications. And now that the Supreme Court has spoken, the question arises also, were those who tried to flag the Imam and Khalid incarceration as a sign of growing autocracy in India, were they playing a political hand to further a political interest? That's the question, the political question that we're looking at. But the more substantive legal issues, let's quickly speak on them. And I also must remind you that we are going to have Harish Salve, Mukul Rohatgi and S.V. Raju, all these three individuals, speak to us and hold forth on the implication of this judgment that's going to come in the second half. So do stay tuned for that. It's going to be very well informed, that particular conversation. S.V. Raju, particularly the Assistant Solicitor General, who has been representing the government's case in this particular matter. Mukul Rohatgi, a former AG, and of course, Harish Salve, former SG. But that doesn't mean, viewers, that at the beginning we're going to let things go, because we have with us Karuna Nandi, senior advocate of the Supreme Court, Jay Anand Dehadrai, an advocate also of the Supreme Court, practices there, Pradeep Bhandari, national spokesperson, the BJP. And we also have with us Tehseen Poonawala and Dr. Anand Ranganathan. So let me first begin with Dr. Ranganathan from just a slightly longer view of what this implies. What does this say to you? Because as you know, Dr. Ranganathan, there are many people who've been coming out, and even foreign governments and legislators in foreign governments who've been saying that this is a test case for India's spirit of being a constitutionally tolerant republic. So what does this tell you? That the Supreme Court now concurs with the various prosecution agencies, and in denying liberty, would you say that the Supreme Court has eroded some of our democratic principles? Would you believe that?
Good evening, Rahul, and good evening to my
The only reason I'm asking you, Doctor, is because you're a free speech absolutist. So,
yes, no, indeed, I was coming to that. But, you know, there is smell of blood still. All the perfumes of Arabia will not sweeten this little hand. You know, Shakespeare wrote it, and to paraphrase it, there is smell of breaking India still. All the sibyls of this world will not unshackle this little hand. Fact of the matter is, judges have denied bail to Umar Khalid and Sharjeel, not because of their faith, but because of the judge's faith. And their faith is justice. To claim that Umar was denied bail or that his trial has been delayed for 5 years because he is Muslim. Would they also argue that Colonel Purohit was denied bail for 8 years and faced a trial delay of 10 years because he was Hindu? This is the kind of rot that has seeped into our national psyche. Number one, I speak, as you said correctly, as a free speech absolutist who has, believe it or not, stood for the free speech rights of some of the most despicable and evil characters one could find. But this entire issue is not a free speech issue at all. Giving a hate speech is one thing, and by the way, I include hate speech in free speech. But planning and orchestrating a communal riot, being in the front line of the mob, carrying sticks in their hand, inciting a mob, pushing the police barricades violently, being culpable of unlawful assembly and rioting. Now, this is no longer a free speech issue, Rahul. These are serious charges concerning not a purported hate speech, but rather incitement and planning a riot. Number two, yes, Bail, they say, should be the rule and jail the exception. But let's talk common sense out here, shall we? Not every under trial gets bail. There are rules for granting bail: flight risk, threat to the nation, destroying evidence, coercing witnesses. These and many other aspects are deliberated by courts before bail is granted. Now, in this case, why should there be an overriding of this process, especially when A, the former Chief Justice is on record saying the defense was deliberately delaying the hearing and pleading adjournments, and B, the bail has been heard and deliberated by the court dozen times, 3,000-page charge sheet, 30,000-page electronic evidence, 133-page order, following which they have denied bail again. And by the way, 75% of all prisoners in India are under trials, rotting in jail without bail. Yes, that system has to be corrected. But Umar Khalid hasn't been singled out, neither has Sharjeel Imam. Just that you care more about them than a million others.
No, but I mean, that can't be the argument. Yes, fine. Of course, there are hundreds and thousands of under trials, as we know, and people who've somehow stayed in jail even without trial. So there are precedents here. It's not as if they are the only two. But there's a larger issue here because some people are saying that the Supreme Court has carved out a national security exception to the principle that bail is the rule and jail the exception, and therefore we have a problem on our hands, Jay Anant Dehadrai. That's what some people are saying, that look, from now on, if 5 years of pre-trial incarceration does not justify bail, therefore delay, which is a very consequential issue, is legally irrelevant in UAPA cases. We should never even invoke this principle. That's what is being said.
Rahul, good evening. At the outset, I'd like to frame this a little differently. These individuals, they're being portrayed as some sort of student activists, who were simply giving a speech in their college canteen, and now things have taken a terrible turn for them. That is not the case at all. These individuals, and please make no mistake about it, are terrorists. There is a definition, a statutory definition within the UAPA under which they have been charged, and what they've done in terms of planning, inception, and even carrying out some of the activities that they've undertaken. All of it, satisfy the definition of terrorism in terms of the UAPA. These are unlawful activities. And please remember, this law came in during Mrs. Gandhi's tenure. This is not a law that has just come in the last 10 years or so. That is one aspect of it. Second, the Supreme Court at this stage, Rahul, has only determined bail. This is not, they have not decided on their innocence or their guilt, or, they've not pronounced on any of those aspects. So there is no requirement of a mini trial at this stage. The only requirement is that there is a statutory prescription in terms of Section 46. There are some conditions that have to be shown to be fulfilled. The Supreme Court agreed with the High Court that those conditions were not fulfilled so far, which is one, as Professor Ranganathan very rightly points out, that a prima facie case had to be shown. And in this case, let's not forget these two individuals. There are speeches on record asking for India to be split.
I'll come to that because you see, pre-trial detention was a serious constitutional
concern. I'll come to that. I'll just come to that if you just allow me.
They spent 5 years in jail.
No, you've raised a very, very important point that, there is this sense now, there is this narrative that is, sought to be peddled, that there has been this delay and therefore they should have been given the benefit of bail while trial is still pending. But the issue is, and this is something that the High Court has also seen separately, and this has also been recognized and confirmed by the Honorable Supreme Court, the delay was entirely attributable to their own conduct. Now, there are instances where they would move unnecessary applications before the trial court. Now, I'm essentially a trial lawyer, a criminal trial lawyer. They would move unnecessary applications, refuse to argue on dates which had been fixed by the trial court. And then once their bail applications came up in the Supreme Court, there was one particular bench that they didn't particularly fancy, Rahul. So they would simply withdraw their bail application every time an application would come up before a bench that they did not like. So this is all well and good. My big grouse, I just want to say one more thing. I have a big complaint, in fact, with the judiciary. Twofold. One, according to me, even the other 5 cretins ought not to have been granted bail in a case like this. They were basically trying to destroy the integrity of this country. That is one aspect. Second, according to me, this trial should not take so much time. They should it should be time-bound. Within a month, they should wrap it up. And if there is enough evidence, I'm not prejudging whether there's enough evidence to convict them or not. But in fact, if there is, this is a matter of great national importance. And if they're guilty, they should lock them up and throw away the key, which is what the law requires. There's life imprisonment in a case like this. So this is my grouse with the judgment.
Okay, so 1 second. Karuna, one second, doctor. Let me just bring in Karuna Nandi. Karuna Nandi, Where do you come in on this? There are some people who are talking in terms of wanting to adduce a caveat to this by suggesting that, pre-trial detention was a serious constitutional concern. These people have spent 5 years without trial, and once liberty is robbed, it can't be sort of reinstated, as you know. So people say that the Supreme Court has willy-nilly gone ahead and sort of made even the principle of delay irrelevant in UAPA cases. How do you respond to those people who are saying that? Are you sort of in favor of this view, or do you believe that the Supreme Court has acted justly, fairly, and also seen to be acted justly and fairly?
Thank you for that framing, Rahul Shivshankar. As I think you quite rightly observed, the UAPA is a statute that is not above the Constitution of India, right? And in that regard, the Justice Khanna, I think, had said that even in UAPA cases, Article 21, the right to life and the right to, therefore, freedom, also very much applies. Now, in this particular case, why is there so much dissent from the Supreme Court judgment? Why are people critiquing today's order in the way that they are? I think that the reasons are threefold. There are three limbs to the objection. The first limb is the fact that the reason that judicial scrutiny is required in the way that normally a mini trial would not be held is because the law is so framed in such a way, is that when there is such a long incarceration of 5 years, that type of very strict scrutiny, I think, is very much required. Number two, if you look at the conviction rates under UAPA, I think they were about 4% if you look at the average over the last 6 years. So if you also now look at the fact that there is no recovery. There is no, and a recovery is that if you are saying that there was certain things that were said and that something has been obtained as a result of the thing that was said, and that thing links the person to the crime, that is what a recovery is, right? In layperson's things. There was no recovery. There was no overt act. There was no material link to the violence. Now, given the absence of these three things, and the fact that supplementary charge sheets continue to be filed over and over and over again, contributing to this incredible delay in the trial. And the fact that these charge sheets have, a number of charge sheets have now already been filed. And there is no possibility of then interfering with the evidence. Why is this man still in jail? If you look at the speeches, and the speeches are there for public consumption, and if you look at the speeches, in the speeches, what he says, Mr. Khalid, is that we should not answer violence with violence. We must answer violence with peace. So, in such a situation, the kind of scrutiny and the kind of principles that our court has itself applied in a number of other cases, in my respectful view, could also and should also have been applied in this case.
Okay, so let me bring in the BJP national spokesperson. Yeah, Mr. Dehat Rai, on that point of law, very quickly before I bring in the BJP national spokesperson. Yes.
Very respectfully disagree with the earlier speaker. There are speeches on record of both of these individuals. In one of them, he says something to the effect that India is illegally occupying Kashmir and that he recognizes the right of the Kashmiris to self-determination. What are these people talking about? I mean, is this the sort of, is this some schoolroom speech that they're looking to defend? That is one aspect. Second, in the other speech, the other gentleman, Sharjeel Imam, he goes on record to say that there are 5 lakh Muslims waiting in the wings to split the chicken's neck, and we can split India for some time, from the rest of the country.
Ms. Nandi, there's also supposedly evidence on record,
Rahul,
electronic evidence, WhatsApps, this, that, the other.
May I say one more thing? The preamble of India, if you go to the last paragraph, the last phrase in the preamble of India, it talks about dignity, fraternity of the individual, but it also talks about integrity of the Union of India. the integrity of the country, which trumps any right to liberty which people like, anybody is claiming.
Ms. Nandi, yes.
What is the allegation here? What is this case for? This case is for an alleged role in the Delhi riots, right? So anything that somebody may have allegedly said, and I don't know if this is true or not, and this is not something that would be the list in this case, and about Kashmir or some other state, would not be central to the Delhi riots, firstly. Secondly, this other thing that is allegedly being seen, I'm told is being denied. And so if it is being denied, then that is something that is very much a matter of trial.
Okay.
So what is being said and then concocted here?
No, please see.
Okay. Let's not get into, look, we are not a court of law.
Just one important thing, just one
thing.
thing.
One second.
If one goes through the judgment, there are references to WhatsApp messages in which there is a discussion about
so you're saying that
jam in Delhi.
I've seen that.
Yeah.
The court, prima facie, believes that there is enough evidence that has been adduced on the record to suggest conspiracy. Look, I don't think even the court intended to right now pronounce judgment on the quality of that evidence. I think we're still on the question of bail. Gentlemen have been given a year to come out and file another appeal. And the prosecution literally now is on test for 365 days. So I just want to bring out Pradeep Bhandari there. Mr. Bhandari, why is the BJP calling this such a vindication of their stand when the Supreme Court is being questioned so minutely in its own interpretation, and that many people are saying there's a blurring of lines now between dissent and, of course, sedition, or call it what you want, or terror in this case?
Well, Rahul, let me begin and ask a very fundamental question to you, and through you, the crores of viewers which watch your show. A gentleman who says, and I quote Umar Khalid, who I believe prima facie is a traitor, says that Jammu and Kashmir has been illegally occupied by India. This is the evidence.
Yes.
Okay, so, yeah.
Can a patriotic Indian, if I would not have told you that this audio belongs to Umar Khalid, these are the exact words of even a terrorist like Hafiz Saeed who carried out the 26/11 attack. I ask a second fundamental and a prima facie question to you. Can you, Rahul Shiv Shankar or Anand Ranganathan or anybody on the panel can ever say in their dreams as a patriotic Indian that they will remove chicken neck from the Indian state? This is exactly what is being said, and I'm quoting, this is verbatim being said by Sharjeel Imam, and he was conscious when he said it, and this was on the time when Delhi riots were being carried out. Point number 2. So they are not normal activist individuals, innocent, because the fundamental of the Indian constitution, which the former speaker was speaking about, is the Indian preamble. And the word of the Indian preamble is, we the people of India are solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. And above all, it is about the integrity of the Indian state. So if two gentlemen do not believe in the integrity of the Indian state, then Article 21 does not apply to them as it is applied to a normal citizen. This is not what I have said or the Supreme Court has just now said. Even in February 2024, in M.N. Sundresh, the Supreme Court said, and I quote, mere delay in trial pertaining to grave offences cannot be the ground to get bail. And if you recall, the ex-former Chief Justice of India, Justice Chandrachud, has also said that the delay in trial is on the part of the accused, not on the part of the state. But what is the fundamental question? The fundamental question is that what we as a state will accept and what we as a state will not accept. Because if we call Sharjeel Imam and Umar Khalid as innocent and try them and give them bail, then a precedent will be said that any quote-unquote intellectual or an academic or a doctor who wants to plot an attack or whose thoughts are such that which believe in a weak Indian state or do not believe in the unity and integrity of India will say that he will give a statement, will be in the jail for 5 years and will automatically lead a normal life. They cannot lead a normal life and a precedent has to be set. And towards the end, let me quote what Umar Khalid has said about a terrorist, Burhan Wani, and I quote Umar Khalid. I don't think he is a terrorist. He is exactly doing what Sheikh Arara had said, and Umar Khalid is an innocent who believes in freedom of Burhan Wani is an innocent who believes in freedom of expression. Burhan Wani is a terrorist who carried out attacks against our forces. So the two gentlemen which we are speaking about, their thought is not in favor of the Indian state.
Okay,
they do not believe in the integrity
so then
of
let me
India.
ask.
And the Congress party under Rahul Gandhi exactly, precisely backed them.
Okay,
and you have cities
one
of
second. Let
opposition
me
leaders
bring
who
in.
are calling them as victims.
Let me bring in the other side. Tehseen Poonawalla, very quickly. Were those who tried to flag the Imam and Khalid incarceration as a sign, perhaps, of growing autocracy in India, were they playing a cynical political hand? That's the question.
Rahul, thank you so much for finally getting me in. A good evening to you, to all the fellow panelists. 3 or 4 things. I agree with the last point Jay made, that this trial should be over quickly. I'm not a supporter of Umar Khalid or of Imran Sajid. For all I know that they are rodents, please, by all means, convict them and throw them in jail. But as so far as bail is concerned, because that's what we're discussing. We're not discussing what they said about Kashmir. We're not discussing what they said about anything else. We're discussing their right to bail. As so far as bail is concerned, as long as they're not at flight risk, tampering with the evidence because the charge sheet has been filed, or they can influence the trial in any way, bail should be given. That's point number 1. And I stand by anyone else who's not got bail. I am very clear, whether that is the colonel, whether that was Pragya Thakur, whether it is these people, bail is a right, not jail. That's first point. The second point of this, the BJP spokesperson is so wrong on the constitution, but then, BJP and constitution don't go hand in hand. Article 21 applies for everybody, even if you're not an Indian citizen. Article 21 applies. You don't have to, please don't interrupt me. You don't have to be an Indian citizen for Article 21 to apply. It's the mother of all fundamental rights. Now, the third point that is out here. Look, at the end of the day, the courts must reflect within. Why should somebody who said such things and is such a danger to India not being tried immediately and set an example before the world? Why is whatever things that they are trying through their lawyers, that charade being allowed to continue? Now, the last point. The BJP has been in alliance with political parties or political organizations or militant organizations or quasi-militant organizations that just did not believe in the Union of India. They burned the constitution. Even today, some of them believe in a state outside the Union of India. The BJP has been in a political alliance with them. Why is that different? I'm again saying I don't support these two gentlemen, but I'm saying try them and throw them in jail. The facts are not in dispute.
Dr. Ranganathan.
Allow me a rebuttal because Tehseen made a personal comment, please.
No, he didn't make any personal comment.
No, I made any personal comment. I would never do that.
He
I would never
made
do
a
that.
rhetorical comment. No, one second, please.
I would
Just
never
one
make a
second.
personal
No,
comment.
one second. Dr. Ranganathan, yeah, very quickly. Yeah.
Very quickly, to a couple of points. The reason why I admire my good friend Jay is that he is a lawyer and a good lawyer because he understands what law is. Law must not be intertwined with emotion or worse, activism. And that is why Jay is a very successful lawyer. Now, 2 points. Number 1, when we are talking about this case specifically, 2 things spring out. I already said, I am a free speech absolutist. I have no issues at all. For so many people, when they say India is occupying Kashmir, let them say that. There are chief ministers who've established Burhan Wani as a youth icon. There are people who wanted to cut off India. Have they been arrested, chief ministers? No, they haven't. So I am a free speech absolutist there, and thereby it merits my saying that this is a case where the 30,000 page electronic evidence and the 3,000 page charge sheet actually indicts these 2 gentlemen into taking a full-fledged active part in the riot, in being in cahoots with Tahir Hussain. Therefore, 7 judges have looked at that, not as some 2 piddly little speeches which you may or may not find incendiary. Number 2, I repeat again, is giving bail a rule? I speak as a common man. If it is not a rule, then it is subjective. It is subjective to a person being judged thinking a person is flightless, is coerced the evidence, is going to hide the evidence or coerce witnesses. I'll give you one example. Yeah. There is a court case going on against Rahul Gandhi in a court where he's supposed to have made incendiary speech against Savarkar. You know what happened? Charge sheet and evidence had been submitted. Suddenly the CD has gone missing. So it's not enough to say that a person cannot coerce or remove the evidence.
Okay, on a point of law, very quickly, 10 seconds, 20 seconds from both the lawyers. Ms. Nandi, let me ask you this. If 5 years of pre-trial incarceration does not justify bail, is delay now legally irrelevant in UPA cases as a basis for bail? Very quickly, ma'am.
We hope that this is not true, that that the same court perhaps only a year from now, perhaps future, will set this right.
Okay.
In line with the judgment in Twaha Faisal, in the line with the judgment in Devangana Kalita, in line with the jurisprudence of this court, which is clear on a number of issues. Number one, where there is no recovery, where there is nothing connecting somebody's speech to particular violence, and where there is such significant pre-trial incarceration and a charge sheet has been filed, that bail is the rule and jail is the exception, and this is a principle that our higher will follow.
Jayanand Dehadrai, on this
Rahul,
point.
very quickly, the court itself has answered this question in the judgment. The court has said very clearly that the facts of every accused person have to be judged separately and individually. And there is no straitjacket formula that can be applied, especially in cases that concern put in danger, the national security of our country. So that has already been answered. That is one aspect. And the other thing is, in the case of these two individuals, I can't even call them gentlemen, as my friend from the BJP very politely has referred to them as, but they have been referred to as coordinators and mobilizers, both of these individuals. And as Professor Ranganathan very rightly points out, right after these speeches and their so-called activism, we lost a lot of people, innocent people in Delhi to the riots in Delhi. So there was absolutely a cause and a reaction to, to what they've done.
Well, we leave it at this with this esteemed panel.